avoid illegal discipline of employees for conduct outside of work. Joining me today is Brian Shenker, counsel of Long Island and New York office, Jackson Lewis P.C. Brian's practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. Brian has extensive experience defending class and collective action lawsuits under federal and state wage and hour laws. He has successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor. Brian regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. And a regular guest of the show. Brian, welcome back.
Thanks for having me, Mike.
So, Brian, this is the topic that we never would have imagined we had to deal with in HR when we were growing up, right? And I'm older than you, so at least when I was growing up, it wouldn't have come up. But today, the lines have blurred so much between when are we at work, when are we at home, what's work time, what's personal time, because it's not defined by the commute in the brick walls that we show up to work. You know, the personal and work lives are so intertwined, and social media is so pervasive in all the things we do, including using social media for work. So maybe just if you could kind of paint a picture for us of the how the landscape here is changing in maybe some of the laws that are starting to emerge. Certainly, you know, New York, California, it's where most of these things start. How the law is addressing these blending lines between work and social media.
Sure. So it's an interesting area because, you know, many employers might be of the opinion that, you know, there's not much regulating them in terms of how they can regulate their employees outside the workplace, right? If an employee does something you don't like and you find out about it, you know, outside of work, many business owners may think, look, I have, you know, the full right to, you know, take any discipline I like because it's at will employment. But there, like you said, there's actually many states, there are actually over 30 states that prohibit in some way an employer taking action against employees for certain off-duty conduct. These laws widely vary. There's not much at the federal level, so, you know, we're looking to your local state jurisdictions. But, you know, they often prohibit the employer from taking action against employees for lawful off-duty conduct. So, you know, for instance, California, California has a law that no person can be demoted, suspended, discharged, or otherwise discriminated against because of any lawful conduct occurring during non-working hours. California actually, you know, does not have exceptions to that. You know, many other states, for instance, Colorado, have similar rules on the books, but they have exceptions. So again, you know, Colorado, similar rule that, you know, employees can't be terminated for lawful activity off the clock. But there are exceptions for, conduct that's, conflicts with the employer interests, or that conduct that may be reasonably related to employment activities. So, you know, there are limitations both in those laws. And look, as we'll discuss, the National Labor Relations Act, the NLRA, which is enforced by the NLRB, the National Labor Relations Board. Even in the non-union context, there are laws that govern what private employers can do with respect to this off-duty conduct. Brian, there's a lot of laws out there, and not just, you know, one in particular. So we really have to, you know, be careful as we'll go through.
So maybe before we even start unpacking the specific laws and some more specific guidance for employers, that we're not. I opened this conversation up talking about social media, right? But we're not really just talking about social media, right? I mean, this is, you know, if you're a large national employer and you work remotely in a different state and you stumble out of a bar drunk and make a fool out of yourself and get arrested, probably not doing a lot of damage to the brand. But if you are working for the local church or synagogue and you do that same thing across the street, there might actually be business ramifications, right? Can you speak to the conduct outside of work, not just as it ties to maybe social media? And we start with that because I think it's obvious social media has just accelerated and created so much transparency, whether it's desirable or not, into all this kind of behavior.
Yeah. So yeah, when we're talking about conduct outside of the workplace, I think, what I generally guide employers on is that, look, we want to focus on, not the actual conduct, because as we discussed, based on various laws, the employer might be limited. But we really want to focus on what's the impact, what's the business impact. And like you mentioned before, right, someone who gets arrested, maybe a high profile arrest, for something, that can have reputational harm for a company. There, could be issues with competitors, right? Someone starts, moonlighting, right? They have a second job, and right, we might not govern whether they have a second job, but all of a sudden, they're working for a competitor, and they may be providing, that may itself be a conflict, and the employee may also have the ability to give confidential, trade secret information to that company. So, a lot of this comes up in ways where, we don't necessarily want to look at the conduct itself, but how it, results in, maybe, some poor performance. For instance, one great example of this would be where we are with cannabis in the country right now,
right?
Where in many states, it's either, legal medically or, in more and more states, it's becoming, recreational use is okay. But at the same time, we don't have tests that can, drug tests that can identify if someone is impaired at that moment. So, one of the common things I counsel companies on with respect to cannabis use is that, look, we're focusing on the activity of the work, right? It doesn't concern me if all we think is that, Jenny sitting at her desk, might be high because, her eyes are red, are bloodshot. That's not necessarily a concern, but is Jenny not performing any work today? Or does, Jenny, use machinery, and is she, not operating that correctly? So those are the things we want to look at, how it impacts the business. But speaking of cannabis, as we're on that topic, more and more states are passing laws on this that are protecting employees who use cannabis. California California is always passing laws, but starting in 2024, California employers will be prohibited from discharging employees or refusing to hire individuals based on their off-duty use of marijuana. Now, their law, it differentiates between testing for CBD and THC. THC being the part of the marijuana plant that gets you, high. CBD potentially not so much. So, the laws sometimes differentiate between, those types of chemicals. But we're seeing more and more of this. For instance, New York has also made it unlawful to, take action against employees because of off-duty cannabis use.
Brian, I want to go on a little tangent on this one. So this is something we talk about a lot. So in the cannabis is a good topic. Because it can be kind of a polarizing thing. I mean, clearly the sea change is happening from a legal construct in dare I say, a social acceptance. There's plenty of people who think, hey, this is still, I'm opposed. This is illegal at the federal level. But one of the things we always talk about in HR is you have to comply with the law, and it's usually the strictest of all laws that you must comply with. So you don't get to thumb your nose at state or local, say, overtime rates just because the federal says 735, right? So if your locality, if your state says it's $8 and your county says it's $10 and your city within the county says it's 15, guess what? It's 15. So can you speak to that specifically on cannabis for somebody who might say, hey, this is federally illegal. I can crack down. I don't have to allow my employees to do this.
Yeah. So right. So at the federal level, right. You're right. So recreational, cannabis, weed, it's not legal at the federal level, but states are legalizing it in many ways. And along with that, what employers need to recognize is that, those states are, issuing laws that will govern how this is treated. So, right, oftentimes, this off-duty conduct area it's funny, oftentimes, like you said, we're dealing with, strong federal regulation like in Title VII,
right, or
the FLSA that sets the floor. Here, there's really an absence of action at the federal level governing this. So, unfortunately, right, that means if you're an employer, for instance, in New York, who does not think that, individuals should be, using legalized marijuana, that's going to cause some issues for how you can actually regulate employees. For instance, in New York, right, like many states, there are 30 or so states that have similar off-duty conduct laws, but New York's prohibits employers from discriminating against employees for engaging in lawful activities, including political activities, recreational activities, and the legal use of consumable products, where that occurs outside of working hours, off the employer's premises, and certainly without the employer's equipment or property. Now there are exceptions to that. And many states do have exceptions. New York, for instance, has an exception where the lawful activity would create a conflict of interest for the employer's business. But now, like I said, the New York off-duty law covers cannabis use. So I mean, look, obviously, if you're a federal contractor and you have a contract that does not permit cannabis use, that might be take you out of this rule. But again, generally, that means employers can use cannabis off duty. Certainly employers in all these states where recreational cannabis is allowed, they can still have a drug-free workplace. So let's just be clear. No one's saying that employees can come into your workplace, with marijuana, with, under the influence. Certainly not. And so, look, if you catch an employee, in your warehouse, smoking a joint, right, that would clearly be a violation of a, no substance use at work and, subject that person to discipline. But where the law becomes tougher in this area is, where, someone, you don't catch them using the drug, but it's possible they're affected.
Brian,
just
this is going to be so easy for us to go down really deep down rabbit holes here, right? Because some of these topics, I don't want it to be a cannabis focused or an adult content focused. We're going to explore that too. But just, can you paint a picture for employers, just some guiding principles of how, I guess there's the discovery of the conduct, but then once it's discovered, what is in bounds for employers to provide disciplinary action, whether it's write-ups, formal performance review, termination, whatever that is. Let's come back to the discovery part because I think that lends itself more to a social media conversation. But what about the conduct itself? Right. if it's legal and it's outside the four walls of the business, so to speak, what rights does an employer have should they be able to exercise?
Right. So typically, especially, in those states where, lawful out of work conduct is protected, there may not be much that an employer can do. What employers should really focus on then is the employee conduct, right? As I mentioned before, you have an employee coming in, acting strange, not speaking coherently, that's the issue. The issue isn't that, they might have, gotten high before work. The issue is what conduct are we seeing? So that's what I always guide employers on, is that, when you write someone up for this, right, it's not going to be, John was written up because we think he was high, he was, eating a bunch of chips and his eyes are red shot. No, that's not what we're focused on. We're going to say, John, when we spoke to him, he couldn't speak clearly. He was mumbling. When he tried to operate the machinery, he wasn't able to, those are what we want to focus on, so that essentially, in the end, in those scenarios, the issue isn't whether or not they were high. They're not going to be disciplined for, being under the influence. They're going to be disciplined for the resultant, activity, the resultant conduct or poor performance. So that's where I think, we should really focus. And look, obviously, talking about during work, I mean, zero tolerance should be, what it is. Even if there's, if it's legalized in your state, I would recommend having, a zero tolerance policy for, substances, just as you wouldn't tolerate alcohol use.
I was going to say, it doesn't have to be a controversial topic like marijuana. I mean, alcohol. I mean, this isn't 1966 Mad Men where you're drinking scotch in the office, right? I mean,
that's right.
What about maybe more nuanced topics? I think about like the inter-office relationship, right? I mean, happens all the time. People work closely together. They become their colleagues. They become friends. It advances into a romantic relationship. What's inbounds? What's out of bounds? How do you guide employers in this area?
Yeah, so that's a great one. And I was actually looking up statistics, and I found that, roughly 60% of employees have reported being engaged in a romantic relationship with a colleague. So, for those employers who don't think this is an issue, it's a lot more prevalent than you may think.
Right.
And look, it's another one. Even though, an employee romance or relationship is, an off-duty issue, it is something that employers can and probably should address. Many companies, let's talk about the risks first, right? Why would you even want to address, workplace, romances? One, obviously, the potential for a sexual harassment claim, right? What's sexual harassment? Unwelcome sexual advances. So, we want to make sure that, when people are having only consensual relationships and we're not seeing anything else. So that's one potential issue. Yeah. And look, it's also hard to spot whether a relationship is consensual or not. It's not always so clear. And then even if it was, something I'm dealing with in litigation right now is when a consensual relationship ends, there can be pitfalls, right? A spurned lover may, act out of emotion and not consistent with company policies. They might make continued advances or sexual requests or intimidate the other individual. All of that could also, subject the employer to a sexual harassment claim.
Right.
So the best way to deal with these,
of the 60% of people who said that they were involved at some point in their life, it's not 60% who end up married and stay married forever. So it's probably the bigger risk is when those relationships ends, what happens, especially if that relationship isn't amongst peers, but there's a subordinate relationship, then you're opening yourself wide up open to whether it's real or perceived retaliation claims, bullying, simply making someone feel uncomfortable. How do employers navigate all this? Because it's not
right.
I mean,
yeah.
I'm
So
the last
I think
guy in
there are
the world who. I'm always the last guy in the office who finds out that two people are together. I'm like, because I'm just blind to it, whatever. So how does the employer know? You can't prevent it. It's going to happen. So what are the policies that you set up ahead of time? When you do find out, what do you do about it, if anything?
Right. So, yeah, I think your point, that's a great point, right? Just because you don't know it's happening doesn't, mean you should, bury your head in the sand and pretend this isn't happening, right? That's going to, create even more risk. So there are really different levels of anti-fraternization policies that companies can implement to minimize these risks. At the one extreme, a company could have a complete ban on personal romantic relationships, and it could discipline those who violate that. Now, the downside to that is, as you can expect, employee morale would be very low. Many could see it as an invasion of privacy or even an attempt to govern off-duty behavior. Right. So typically, I would not recommend trying to institute a complete ban. I think that one of two other options are best. One, at the other extreme, is we're not going to limit romantic relationships. All we're going to do is say that if you're in a romantic relationship with another employee, that you need to promptly report that to the company, right? That gives the company protection in that, if there, for instance, was managerial oversight between one of those in the relationship and the other, the company could remove that, that oversight, right? Because that can often be a problem if two people romantically involved, one's the superior, one's the subordinate. It creates a lot of issues with that power dynamic. So having people report can allow the company to remove someone from that reporting structure. The other thing it allows the company to do is ensure that the relationship is consensual, right? That could be so little as HR saying, hey, talking to both people and saying, just want to make sure, is this consensual? Are you being coerced? All right. Some companies may even want someone to sign something saying that it's consensual because, that can be a big concern. A more middle ground to go with in an anti-fraternization policy would be something that just prohibits certain types of relationships, right? That the company is going to prohibit romantic relationships between supervisors and subordinates or individuals in the same chain of command. Because again, in reality, that's where the issues most often lie when we have that power dynamic. But again, it leaves a company, how do you prevent people from dating, right? you can't necessarily do that. So,
right.
The one I discussed earlier where it's just reporting of it, that can often be more effective because we're not limiting this off-duty conduct. We're just, we want to be aware and just make sure everything's kosher. But yeah, that's something that certainly should be addressed in a policy and by HR because, just ignoring it, that could certainly lead to unwanted, sexual harassment claims.
So Brian, I do want to spend time yet on what's inbounds, out of bounds for discovering these behaviors. It's going to be a social media centric conversation. But so drugs and alcohol use, there's legal frameworks that kind of back into your policies. Relationships, it's tough, it's nuanced, but I think you gave good guidance there. What about just simply behaviors that don't align with, say, mission, vision, values of the company, or maybe values of the boss? I think there's good legal protection, say, for political behavior, but probably less guidance, grayer lines, if you will, around stuff around values, whether it's interests or it's producing adult content online. What's the difference in that versus working at the local adult establishment on the weekends? I mean, help wade us through and maybe start with the easy stuff. There are certain behaviors in conduct that is legally protected, like free speech and political interest, etc. Start at the end of the spectrum, and we don't have to go through the swamp here, but we should address other types of behaviors that are more, I'd say, mission, vision, values issues.
Right, exactly. So, yeah, starting with political conduct, I mean, that's kind of been on display, in the media for a while now. We always, hear reports every now and then of someone who attended a, political rally or did something and then, was terminated by their employer. But, really many states protect employees who engage in legitimate peaceful protests. California, Colorado, Nevada, I think Seattle has a local law that there are over a dozen of these where employers cannot retaliate against an employee for engaging in lawful political activities. There are others like New York, Washington, D.C., Illinois that specifically prohibit employers from taking action against employees because of their political party membership, election-related speech, or political activities. So, many have those. And again, as we discussed, is something where you're going to need to look towards state law. But typically things like violent protests, that's not lawful, right? So once we get things, outside of, outside of the lawful world, we're talking about a violent protest, that's not going to be protected political speech and likely can result in your employer taking action.
So if I see you on
I think
TV, I see you on the local TV station and you're part of a rally, whether I love it or hate it, not actionable by me. If I see you on TV throwing a Molotov cocktail, presumably there will be charges involved, but that is fair game. I mean, two extreme examples, but is that it?
Right, but I think that illustrates it well, right? I mean, one is just, hey, you might be of the opposite political party as your boss. They might be very passionate about it, but just because they see you at a rally or you're supporting the other candidate, that's typically, not a legitimate grounds for discipline. But right, on the other hand, going outside the bounds of law with political activities can certainly lead to discipline under most laws. And, I think what employers generally want to look at is, how the employee's conduct, may reflect on the company and, whether there's an issue, whether that creates an issue. There might be some circumstances where, I've seen this before where a company sees conduct that's, that an employee is engaging in that, might be lawful, but it's, not something that reflects, they think, well on the business. And look, sometimes businesses make those determinations that, you have a tough situation, right? This conduct is probably lawful. I can't take action against them. But at the same time, this conduct looks really bad for my company. Sometimes, I'm not here telling anyone to violate the law, but there may be times when a company has to consider which has the worst repercussions, the reputational damage if I allow this to go on, or the damage if I take action and I have a legal claim. So I think those are things to consider. I think before, look, another interesting area that's come up, and I've seen some reporting on this is OnlyFans, right? And this whole new market, and whether if an employee is on OnlyFans, and obviously for those not familiar with that, it's a place where individuals can go and post videos or content of varying sexual nature and get paid for it. And so that might be something that a boss doesn't necessarily agree with, but in many states that's lawful activity. and may not be something the company can take action on. There's actually a real interesting. Go ahead.
Yeah, I was going to say. So what about?
So there's a real interesting scenario.
Yeah, you go ahead. You got it.
Right. So I was saying there's a scenario where an individual who's on OnlyFans, her colleagues found out about it, and her colleagues spent work time logging into OnlyFans to view her conduct, and the employer subsequently terminated the individual who was on OnlyFans, finding it a distraction to her colleagues.
Yeah.
Now, in that scenario, taking out the legalities of everything, what you have there is someone who engaged in lawful off-duty conduct, and then you have a group of employees who were probably violating a number of company policies by not performing work, by accessing OnlyFans on a company computer, and then not performing work as they got distracted by it. So in that case, I would actually have gone the other way and said it's these other employees who are being a distraction and should get disciplined. But yeah, I think OnlyFans falls in that category typically of it's going to be lawful conduct and not necessarily actionable. Look, if you have a company that has particular interest in portraying wholesome values, and you have a high-profile employee who's on OnlyFans, and that presents a conflict for the business, that might lead to the company taking action. But generally, that type of off-duty conduct is protected in many states.
So that's a super nuanced topic, but can you kind of paint a picture? Can I say, hey, our business is built on wholesome values, and that doesn't align with us, so he or she can't work here? Is that? I'm assuming it's if you're talking to a judge, it's going to be a higher threshold than that.
Right. I think it's going to be higher than that. I'm thinking more like, you work for a church and it goes against the values of the church, right? Because I think, like you said, any company could say, yeah, we support wholesome values, right? And we don't think that's wholesome. So I think it's going to be more that it presents an actual conflict for the business than the actual values that they're just saying these are our values. It's more about the actual business.
So this topic of mission, vision, values, Brian, would the employer literally, and I think I'm giving the correct answer here in my question, but would the employer literally have to prove out why their mission, vision, values are an integral part of the brand, and therefore this kind of behavior, if people would know about it, would materially impact the performance of the company?
Exactly how you put it, right? They're going to have to make that showing, to take it outside of the just, it has no impact on the business. You're going to have to show exactly why that, is, the opposite of the values and the way that the business runs and, what the business interests are.
Okay.
Yeah,
so we talked about go ahead.
Go on.
So we've talked about a spectrum here, right? So you got cannabis use, you've got political speech, you've got relationships, you have adult content. It seems that there's a common thread here in that as an employer, what we should be focusing is on the work behaviors, right? So there may or may not be specific laws that protect some of these things that make it actually illegal for you to act upon. But it seems this little red thread that kind of stitches through all these topics is work behavior, right? It seems to be from a legal framework carves out personal life from professional work life. That hey, what they do in their own time, as long as it's legal, is kind of out of bounds unless you have a really specific use case that we as employers need to be focusing on the actual behaviors, not, hey, because you smoke weed on the weekends, I think you're lazy during the week. Well, I got to prove to you, what does good work look like, and how do your behaviors line up against that, my definition of good work? And have I communicated that properly through job descriptions, employee handbooks, performance reviews, etc.? Am I saying it right?
Yeah, no, I think that's right. And I think maybe a good example of that could be even, in social media, right? Where, someone's own private social media account is theirs. They can post on it as they like, as people these days, certainly do. But, if I start, I won't say myself, if someone starts posting, racist and inflammatory posts, that could lead to discipline, right? For instance, if someone starts attacking, their coworkers and, saying, racist things about coworkers online, well, that's something the company, if it finds out about it, should potentially take action because, while there may be prohibitions against taking adverse employment actions for lawful conduct, those laws typically, exempt from that ban, off-duty conduct that is, that may be offensive or unlawful, right? So online speech that attacks, immutable characteristics protected by law like age, race, sex, religion, disability, or that, could not constitute, workplace harassment, would not be protected. So an employer could find itself having to deal with, social media posts between employees that address these issues. And even though it's off-duty conduct, because it's talking about, a coworker's race, then that brings it into the context where the employer should deal with it. Because that could be part of a discrimination or harassment claim. But at the same time, you can imagine, an employer can't be in a position and, typically are not in a position to police everything, right? They can't police every complaint that comes up or every social media posting.
Right.
Right. So like we said, it's, ones that create reputational harm. Those can certainly be concerns for an employer. Those that can create a discrimination claim, right? That's another type of off-duty social media posts or other type of conduct that can be concerning.
Right, Brian.
And so again, think of this, right?
I'm curious around social media. What is inbounds to discover in the first place? So,
sure.
If I'm interviewing a candidate, I'm on the phone with them in an interview. I'm looking at their resume. I've got their LinkedIn profile in another tab, and I've Google searched them, and I'm just looking at Google Images, seeing where they show up. I'm looking at Facebook, and if they show up there, I think I'm on solid ground if it is publicly available for me to try to get a picture of who this person is. Now, I can't discriminate based on any of the protected class, whether it's age or gender or religion, et cetera, race, et cetera. But that is all fair game for me, isn't it?
Absolutely. So, sometimes employers do get tripped up in, social media during the hiring process, which, as you mentioned, can be a valuable tool because you learn more about this person than what's just on their resume. And so, many companies will vet, candidates through social media. But, there are potential pitfalls, right? The most obvious one being, right, like you said, I see that someone is, a certain race or disabled or of a certain religion based on their social media posts, and then I don't hire them, right? That's clearly discriminatory, and the EEOC, has taken the position on that, anytime you use an applicant's or employee's, social media as background, that, the company should, not be using any protected characteristics as the basis for a decision. So that's the easy one. But then, talking of LinkedIn, there was an Illinois federal court case that involved a company that a claim by the employee that they engaged in age discrimination against an applicant. And the applicant alleged that the company looked at his LinkedIn, found out that he was, in his 50s, and based on that, didn't hire him. And the company said, well, we don't know what his birthday is, but the court said, well, looking at his LinkedIn, you clearly could have seen what his graduation date from college was and determined that he was over 40. So, there are things you also don't want to find out on social media because
can we pause on that one, Brian? Pause on that one, because, God forbid, we're advocating for employers here, right? And maybe that's the wrong way of saying it, but trying to provide the best information we can for employers. How the heck do you protect yourself if I might interview someone and they're a bozo. They're a terrible candidate. But if they fell into a protected class, how do I protect myself from not getting sued? Like in the use case you just gave, it wasn't because this guy was old that I discriminated against him. It's because he was a terrible candidate. But yet he can sue me for that. So how do I best protect myself?
Yeah, so a couple pieces of advice for that. So I think one is that the decision maker should typically not be the one looking at the social media content, right? That's, and there might be more than one decision maker. So let's take those decision makers, and they shouldn't be the one scouring, Facebook, Instagram, LinkedIn for information on the candidate. We should have someone else. It can either be someone within the company or potentially even a third party that would look into social media. And that way, we are using internal procedures, to limit the information that the decision makers get. So therefore, someone might claim, well, the company accessed my Facebook, they knew this. And we can say, look, here are our controls. That never made its way to the decision maker. And this way, only relevant information from social media, right, which would be information not related to protected categories, would be conveyed, right? Look, if we have someone, going out to parties and they're drinking in every single picture, right, that might be, they're partying, that might be something, but then, we're not going to show them the, photos with, in the same sex relationship or something like that, where, it might give, a hiring manager, pause or some concern, obviously not legitimately, but, some people have, either, explicit or internal biases. So I think that's one way, don't let the decision makers, see that information. And I think, another one is just having clear policies about what's being done and being consistent, because, what we don't want is, a hiring manager looking up one person's social media account, but not the others. Well, why that person, right? So we need to decide as an organization, are we doing this? Are we looking into Facebook? Are we looking into their social media, or are we not? And, it should be consistent so that all people within the same, classification are being treated the same. So I think that, that's very important to make sure that, managers aren't just, going off the rails and, searching people for some, maybe, illegitimate reasons, on social media.
You know what?
And then look,
people are going to get sick of us saying this, but it's just so relevant. Good HR, good leadership requires documentation and communication, and it looks an awful lot like an employee handbook and a job description, right? It's so easy to dismiss those really simple things, but if you have a job description, and in that job description you talk about the competencies required to perform the job, and then you have an interview, go further upstream than interviewing. You have an application process that is the actual job application and the posting itself, and then an interviewing process where you can have documented questions and documentation of the answers they provided, how you're mining for those behaviors and those competencies. then you can get sued for any reason, whether it's discrimination or whatever. Winning a case is a very different thing than just simply being sued, right? But while we can't prevent anybody from ever getting sued, you can protect yourself and at least lower the cost to defend. Because as soon as the other if they don't have somebody with Brian Shenker's prowess on the other side of the table defending, as soon as you provide the documentation, say, hey, here's the job description, here's the interview process, here's the questions that were asked, here's their answers, and therefore it wasn't a match, especially when compared to this other candidate that we did hire. I mean, judge might throw it out. You might still have a little cost to defend, but the more you can document, the better, right?
Yeah. No, exactly. And that's why a lot of this comes down to, what effect is this off-duty conduct having on this individual's performance of their position? And, oftentimes, if a company honestly looks at it, the answer is none. And so, sometimes just because as an employer, as a person, you disagree with, what they may be doing with their own free time, that's not typically, regardless of what your state law says, that may not be a very good reason to take any action against someone, because employers are in the business of whatever their business is and driving their business, right? We're not trying to have all employees act the same way. It's if you're a productive employee and you're performing the right work, then you're valuable to the company, regardless of whether you engage in political rallies, on the weekends or something like that. But I do, coming back to social media and the pitfalls there, I think there's one other area I'd like to spotlight where employers typically don't understand, especially non-union employers don't understand that the National Labor Relations Act can impact them. And so we're not going to do a huge dive into this and explain all about the National Labor Relations Act, but I'm just going to discuss one section real quickly, and that's Section 7, which guarantees the right to self-organization and to engage in concerted activities for the purpose of mutual aid or protection. So, what's concerted activity? Because this is how this applies to private employers. Concerted activity is basically when more than one employee get together and they discuss wages, hours, working conditions, or they try to get the employer complain about those things, get the employer to change things. So any discussion essentially about working conditions among employees can be concerted activity, and that is protected legally at the federal level, and you cannot discipline or terminate someone for that. So how does this relate to social media? Okay, so the best way to this is an example, right? So, the NLRB actually gives a good example here. So an employee, after, complaining to management about, a large workload, went onto Facebook and commented on his Facebook, something like, a bad manager can take a good staff and destroy it, causing the best employees to lose motivation and leave. And then two other coworkers commented on it. One liked it and one commented. And the NLRB found that, yes, this would be concerted activity because that act of discussing conditions is protected. And so you can think of examples where an employer might try to take action against employees for this, right? Other Facebook postings, right? The simply liking a Facebook post by a coworker has been found to be concerted activity. So if someone's complaining about working conditions on Facebook and another employee comments or likes it, that's concerted activity. We can't terminate that employee or discipline them for doing that. So that's something where, if an employer is going to start looking into social media accounts and the activity on social media of its employees, you need to be careful that if you're going to take action, number one, it's compliant with your state law, including any restrictions on off-duty conduct, but that it's the conduct that you're basing the discipline on is not related to concerted activity, meaning multiple employees discussing working conditions. So that's something where, again, the NLRA, it's something we all think just applies to union shops, but this is really the National Labor Relations Board, tentacle into private employers.
Yeah.
So Brian, something certainly to be aware of.
You and I have discussed this many times. I've talked about it with other guests. It's just clear there's a sea change going on from a legal structure, that the power is shifting to the employee, right? Both from a legal perspective and just the laws of supply and demand, who gets the power in the negotiation. With unemployment rate in the 3.5% range, there's a worker shortage. There is a labor shortage. This is no longer just a big company war for talent, intellectually interesting TED Talk. This is real. Small businesses are struggling to find good qualified employees, and the legal framework is tilting more and more towards protecting employees. To me, the punchline is you got to have great HR. You got to treat your people well. Otherwise, it blows up in your face, right? It's not. There's no legal tricks. I should say there are legal tricks. There's good, sound legal advice and counsel we can give employers, right? And we've talked about that. It's employee handbooks, it's job descriptions, it's documentation, it's notes, it's solid communication. All good legal and HR advice. At the end of the day, if you're not treating your people really, really well, guess what happens? They do things like talk about you in social media in a public way, and there's not a damn thing you can do about it, right?
Yeah, I can tell you how many times I've gotten inquiries from employers. How do I get a bad review down from one of these job posting boards? Right. And really, there's not much, if anything, a company can do. And again, it's treating employees with respect, and that's generally giving them clear guidelines, treating them with respect. That's the way to avoid most issues, and treating them consistently so they know what to expect. So again, along those lines, right? Talking about how we treat people and giving them expectations. A handbook, an employee handbook, should contain an off-duty conduct policy. Right. But I will tell you this: that policy won't, it's not going to be so robust to address all these things we discussed today, because the main thing and the main thrust of what we've said is that there's no issue for the employer until the employee's conduct starts impacting their performance or creating other issues, right? So oftentimes, if you're disciplining an employee based on off-duty conduct, it's probably going to be governed by something other than your off-duty conduct policy, right? Like you have someone on Facebook is posting comments to another employee and harassing them, right? That's off-duty, but that's going to likely come under the company's, anti-harassment and anti-discrimination policy. So lots of these, someone's moonlighting on it with a second job, and that's then they're working for a competitor. That's obviously not something that a company is going to want. So that would probably be covered by a conflict of interest or non-solicitation, provision in the handbook. But what an off-duty policy, should say, especially in these states, the 30 or so states where there are laws protecting off-duty conduct, is that it'll be consistent with that state law, stating that the company won't take adverse action based on lawful conduct outside of the workplace. And any restrictions should really focus on the effect of the off-duty conduct on the employee's job performance. Typically, we'll have some other provisions. I always say add a National Labor Relations Act saving clause that basically will just say that nothing in this provision is intended to limit the rights of employees under that law or protected concerted activity. That's always a good one to include. But again, having something that addresses this, having clear policies besides the off-duty policy will really set the stage and let employees understand how they're expected to behave, and how the company will treat behavior that impacts the company's business, reputation, or the employee's job performance.
Brian, I know we're about at time. I want to recap two big key points, and I think maybe just ask you to comment on a third. So number one is employers. There's a lot of gray area. There's going to be lots of opinions of what is appropriate, not appropriate. Should I see that? Should I not see that? You can't unsee what's already been seen, whether it's been coming from social media or something you saw just in in your day-to-day life. However, you become aware of certain behaviors. The key here is focus on work behavior, and not out of work, out of office behavior. If the behaviors, whether you like them or hate them, or if they're legal and they're not interfering with the job performance, lean towards job performance. What are the behaviors of successful work, and coach and performance manage based on that, not on what happens outside of work. That does not mean that you shouldn't. Now, point number two, have really good documentation, an employee handbook, job descriptions, open communication with employees. Let me ask you about a third topic here. In a social media world, in bosses who are pretty busy and they're probably not spending a bunch of time on Facebook trying to dig up, see what their employees are doing in their private lives. I'm sure that happens. Can't imagine having the luxury of that kind of time. But a lot of times I think these things spin up internally where, hey, did you hear he was doing such and such? Did you know that she's doing this? And it's the internal distraction amongst employees. What's your HR and legal guidance for an employer to deal with those situations?
Right. No, look, and you make a great point, because typically, unless we're talking about the hiring, area where companies are looking towards social media, you're right. Most scenarios arise during the employment context when coworkers are aware of what's going on, what someone's posting and report it to the employer.
Right.
So, I think in those scenarios, a company should take seriously, complaints of other employees' social media and determine, right? But the company should take the complaint, but then determine, is this something that we should deal with, right? If it's, a social media post that, someone's posting a lot of political things and someone just doesn't like that, hey, sorry, that's not something we govern. But if, someone is posting, let's say, look, perhaps they're posting violent footage of themselves, right? Where the individual's doing violent things that, who knows? I can think of a lot of options, things that could come up, hurting animals, things like that. It might be enough that, that's reported to the employer. And now the company knows that this person may have some violent tendencies. Now, do you have a potential negligent retention claim or negligent hiring claim if you're going to keep that person employed and just, ignore that? Those are some hard decisions where I think, an employer would be best advised to seek, HR or legal advice, because, there is some gray area here as to, certain conduct that could be reported, and the employer needs to decide whether this is something we're getting involved in. This is something that touches on our other policies. Maybe it touches on harassment or discrimination, so we will address it, or it has nothing to do with us and doesn't affect us reputationally or business, isn't impacting this person's performance. but it's just something that might be offensive to other employees. Well, that's not necessarily the employer's place to, get into off-duty conduct that is, offensive to some employees. So, employers will really have to draw lines as to, where they're willing to go and how far they're willing to, take, complaints, especially social media ones. And I just think a lot, of, political, because, that's something that we've seen in the past few years, people can get very heated about. And that, so, I think employers, need to understand, what, and have guidelines as to what they're going to actually address with individuals and what they're not. And I think the best dividing line there is, what affects the employee's performance and the business and what doesn't. Because employers aren't there to address everything that individuals do at any time. That's just, no employer is capable of that, nor they want to do that, even if they were.
I have a friend, she owns a small business, and I think I like the way she handles this, because when you're dealing with social media and others in the workplace who are more likely to be, Facebook friends with a colleague than the boss is, and therefore see things that the boss never would, and then stir up some issue. She makes it really clear in the interview process that gossip is cancerous to organizations and culture, and she won't tolerate it. And if she sees or hears or finds out that you're gossiping, talking about other people about non-work related topics, zero tolerance, you're gone. And she right. maintains this culture successfully, but it's part of the interview process. It's part of the job description. It's part of the employee handbook, where it's explicitly put out there. So to me, I keep pounding this drumbeat, but it comes back to communication, documentation, handbooks, job descriptions, extemporaneous notes, clearly communicating what your policies, procedures, mission, vision, values are. Brian, maybe let me give you 20 seconds. How is it that your firm helps organizations in this way?
Yes, absolutely. So look, we help companies from, the drafting of policies along these lines, all, through, we have a whole labor team that handles all these, NLRB matters. And then look, if it comes to, oftentimes it's more a need for guidance on these issues where, it's a tricky, thorny issue. And admittedly, some of these are where, whatever decision the company makes, there are going to be employees who are unhappy with it. And so oftentimes it's, thinking through these, coming up with a strategy. And, that's what we help employees do, all the while, letting them know what the legal framework is and operating within those bounds. So
all right, very good.
Certainly see this come up a lot.
And at Asure, our part of what we do is provide outsourced fractional human resources services. So the day in, day out job descriptions, employee handbook, making sure all these things are compliant, making sure you have good hiring and documentation and communication practices. Hopefully our job is to keep you compliant in a position that you never need someone like Brian, but inevitably most business owners eventually are going to need someone like Brian. So we have a great partnership, and if there's any way we can help anybody watching today and listening to this broadcast to help you be proactive and stay compliant in a way with a fractional HR resource that costs pennies on the dollars to hiring an internal SHRM certified HR team, we'd love to talk. So Brian, always enjoy talking to you. Thanks for your time today.